Hello, we are insurance coverage lawyers.
We represent policyholders against insurance companies.
Today, we will talk to you about the first step in almost any insurance claim, putting the insurance company on notice.
We will give you some brief pointers on why you should put your insurance companies on notice, when you should put them on notice, and who you should put on notice.
Let's start with why. When something goes wrong, insurance companies want to be notified as quickly as possible. Prompt notice allows insurance companies to act quickly to best defend the policyholder and minimize damages.
The problem is that notice may be necessary before you know whether insurance will cover the damage. Lots of people worry that if they tell their insurance company that something has gone wrong, their premiums will go up. But if you do not put your insurance company on notice and do it in a timely fashion, the insurance company may not reimburse you or pay any damages assessed against you. If you do get sued, the insurance company may not defend the suit against you.
So it's not just important to give notice, it's important to do it on time.
The question of when to give notice depends on the type of policy you have. There are lots of types of insurance policies, and you should read yours carefully to see what it says about giving notice. We'll talk today about two of the most common types of general liability policies: occurrence-based policies and claims-made and reported policies.
An occurrence-based policy could be an old one and not just the policy you have this year. Occurrence-based policies will cover claims when bodily injury or property damage occurs, even if a lawsuit about that bodily injury or property damage is not filed until many years later.
If you are dealing with occurrence-based policies, they usually require that you provide notice as soon as practicable after you become aware of facts that could constitute an occurrence, and immediately if you become aware of a suit. If your notice is so late that it does not meet these requirements, you may not get any coverage or defense for the suit against you. The Connecticut Supreme Court has said as soon as practicable means as soon as can reasonably be expected under the circumstances. You should give notice when facts develop which would suggest to a person of ordinary and reasonable prudence that liability may have been incurred. By way of example, in one of those cases, the court held that property owners should have provided notice when a teenager being towed on a skateboard behind an ATV fell and injured his head on what may have been their property, even though they were friends with the injured child's parents and did not think they would be sued.
The other notice requirement is to provide notice of a suit immediately. That is pretty straightforward. If you get sued, put your insurance company on notice right away.
If notice is late, do you always lose coverage?
Well, it depends upon which state's law applies. If you have an occurrence-based policy, and if the insurance company is not prejudiced by your late notice, it may have to defend you and pay damages anyway.
Here in Connecticut, if the insurance company cannot prove prejudice, late notice will not prevent you from receiving defense and coverage. The Connecticut Supreme Court ruled recently that it is the insurance company's burden to prove that it was prejudiced.
But if New York law applies, be careful. Although New York passed a new statute that excuses late notice, sometimes if there is no prejudice, it does not always apply.
So what is prejudice anyway?
It really depends on the circumstances of each case. One obvious example of prejudice would be allowing a default judgment to enter in a lawsuit before providing notice. On the other hand, if notice is late, but the insurance company, after receiving the notice, never does an investigation or does not miss any deadlines in the lawsuit, it probably is not prejudiced.
As we mentioned earlier, there is one other common type of liability policy, the claims made and reported policy. These policies have very strict notice requirements, and if notice is late, it will not matter if the insurance company is not prejudiced. There is no defense or coverage.
With a claims made and reported policy, you need to provide notice of any claim made against you during the policy period. If the policy has expired, notice is usually too late.
It's possible to have an extension of the policy period just for giving notice, but you have to pay for that extension before the policy ends. If your policy was issued in Connecticut, there is a state regulation that creates an automatic 30-day extended reporting period. You still need to get your notice in before that extended reporting period expires.
It also is important to understand what a claim is for claims made and reported policies. A claim is not just a lawsuit.
These claims made and reported policies usually define the term claim and list lots of things. A demand letter can be a claim.
The definition of a claim is important. If something happens in a policy period that is deemed a claim, then the policyholder must provide notice then. If the policyholder waits until the lawsuit is brought years later, notice will be late, and there will be no defense or coverage for the lawsuit.
An example of this that surprised a lot of people happened a few years ago. The Connecticut Supreme Court held that when a former employee brought proceedings to obtain unemployment benefits, that was a claim that required putting the insurance company on notice. When the former employee sued during a later policy period for wrongful termination, the policyholder was left without defense and coverage because the request for unemployment benefits was a claim under that policy.
We have talked about why to give notice and when to give notice. Now let's talk about to whom you should give notice.
Often, more than one insurance policy may cover the same event.
You may have umbrella or excess insurance above your primary policy. If you do, you generally should put any insurance company with policy limits that could be exposed to the claim on notice right away. That umbrella or excess company might write back and say that its policy is not exposed, but that is better than waiting, finding out that damages are significantly more than anticipated, and then receiving a denial because of late notice.
If you have occurrence-based policies and you have a situation where the property damage occurred over many years, you may have multiple years of policies to put on notice.
Finally, you should consider whether more than one type of insurance policy possibly could cover the issues raised by the claim or suit. For example, a claim could implicate both a general liability policy and a director's and officer's policy. If so, both insurance companies should be put on notice.
We hope this has helped you understand why to put your insurance companies on notice, when to put them on notice, and who to put on notice.
If you have any questions about notice or any other insurance issues, feel free to contact Elizabeth, me, or any of the other insurance coverage lawyers who are listed on our website. Thank you.